Good morning. Are you Carl Ross?
Yes, ma'am.
And Mr. Ross was previously in court and entered pleas of guilty in cause number 25 DCCR 0093 and 0094 to the second-degree felony offense of collision involving death and the third-degree felony offense of collision involving serious bodily injury. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes, Your Honor, we have.
Are there any additions or corrections?
No.
Not from the state, Your Honor.
Mr. Ross, are you still working at TAS?
Yes, ma'am.
Okay. All right, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find sufficient evidence in each case to find you guilty. However, I'm going to follow the agreements that you made with the district attorney. In cause number 25, DCCR 0093, I'm going to defer all proceedings and place you on probation for a period of 10 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. In cause number 25, DCCR 0094, also defer all proceedings and place you on probation for a period of 10 years. Order you to pay a $1,000 fine and to follow all of the rules and conditions of probation. I am going to order, but hold in abeyance, 180 days upfront time in each of these cases. And what that means is that if there is anything at all that happens at the beginning of this probation where you're not following the rules or anything at all that probation feels like isn't going according to the plan, then I have already ordered 6 months in jail upfront time. The seriousness of what happened and what you did and the fact that you left is just, it's awful. And so the fact that you're working, I think it's important that you continue that, but I'm not going to worry about that at all if you're not doing everything perfectly on this probation. Do you understand? If you follow all of the rules and conditions of probation and you do everything that you're supposed to, the opportunity that you're being given today is huge. You're not going to have these felony convictions on your record. And at the end of the cases, if you successfully complete the probations, the cases will be dismissed and you'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you will be brought back into court. You can be found guilty of both of these offenses, and in one, you could go to prison for up to 10 years, and the other for up to 20 years. Do you understand? I'm handing you in each of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up when she's ready to go over your paperwork. Good morning. You're Donald Owens?
Yes, ma'am.
And this is 24 DCCR 1192. Mr. Owens is charged with sexual assault of a child, set for trial to begin with jury selection next Monday. And what is the announcement?
State true.
All right, then I want to make sure that y'all all understand, obviously after today, no plea agreements unless there is something that comes up very quickly that I'm not or y'all aren't aware of. It is likely to be towards the top of the list since the other old one is gone now. So stay in touch with Mr. Kelly. He'll let you know when you need to be back next week. Okay? All right, you're free to go.
Thank you, Judge.
Thank you. See, Mr. Lewis, you have Naquindon. Oh,
He's right here.
there you are. Naquindon Acleese.
Yes, Judge.
Good morning. Are you Tate Daly?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He's on there.
Let's see, we're going on 179. Mr. Daly, in cause number 25, DCCR 0179, you're charged with the state jail felony offense of driving while intoxicated with a child under 15 from September 2nd of 2024. And how do you plead to that charge? Speak up.
Speak up.
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes,
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year term in state jail prison, but that would be probated. You'd be on probation for 5 years. You'd be ordered to pay a $1,000 fine, follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
In addition, as part of this plea, the state would dismiss cause number 25 DCCR 0180. Is that also your understanding?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Without objection.
It's admitted. Is there any evidence that Mr. Daly is not competent?
There's none, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you are mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back at a later date for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right? Well, yes, sir.
And Your Honor, for the court's information and also for the record, the endangering case under cause number ending in 0180 is not only being dismissed as part of the plea in this case, but also because it is the underlying facts are the same as the DWI.
Okay, perfect. Thank you. I'll sign that dismissal. Looks like it's already come through. So just stop and talk to probation on your way out,
Same
okay?
thing there, so-
Yes, ma'am.
Yeah, okay, thank you. Good morning, sir. You're Mark Garcia?
Yes, ma'am.
And Mr. Garcia, did you get someone hired?
No, I didn't. I can't afford it. I just need a little more time to get the money together.
Well, who'd you talk to?
I talked to like Shores and Alfred's, Wilkerson, Marcus Wilkerson. And then I talked to Willard, James Hall Jr.
Speak up, please, I'm
I
sorry.
talked to Willard, James Hall Jr. and Marcus Wilkerson. And then Leanne Johnson. I tried a couple ones, but I left some voicemails, but I haven't heard back yet.
Okay, so what I can do, Mr. Garcia, you've been coming for a few months. If you, since you did what I asked, you can fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. If you make sure you fill it out accurately and completely, don't just leave it all blank or put zeros. You're going to swear under oath that it's all true and correct, and then I'll take a look at it. Step in front of the clerk and she'll give you that.
Monday?
It is Monday. All right, so you're Brian Mitchell? And Mr. Mitchell, in 24 DCCR 0170 is charged with aggravated sexual assault of a child. Case set for trial to begin with jury selection on Monday, the 29th. And what is the announcement?
State trooper.
We're ready. Can I just have a second, because I thought it was next week?
Yeah, we're down next week. The DAs are all.
I had one over in Orange Judge that, no, that wasn't that week, it's the week after.
You're good on the 29th?
Yes, Your Honor.
Okay, all right, so I do want to make sure that after today, there will be no plea agreements accepted. Your case is likely to be at the very top of the list. It's one of the older ones, and so is there any change with regard to negotiations or anything like that?
No, Your Honor.
Okay, we'll see you back on the 29th then. I'll number the cases tomorrow after docket, and make sure you stay in touch with Mr. Burbank. He'll know the exact trial trial order tomorrow after docket.
That's
Okay?
excused, right?
Yes, thank you.
Thank you. I'll see you next. I had something,
Over for Fort Worth to be here, though.
That's right. Good morning, sir. You are John Van Wright, and this is 24 DCCR 2485 and 15 23582. What is the announcement?
As far as the NTRP, it would be not true, Judge.
Okay.
You're not.
I think we'll just prove up the MTRP first, Judge.
Okay, so let's do this then. Let me get that pulled up. We'll go through that entire motion, and then we'll get an updated report and set it for sentencing. Mr. Van Wright, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. And will he waive the formal reading of the motion?
Yes, Judge.
Mr. Van Wright, in cause number 15-23582, I have a motion to revoke your community supervision. Shows that you were placed on probation July 28th of 2020 for the third-degree felony offense of injury to a child, elderly, or disabled individual, and that was a 10-year term in prison, but it was probated for 6 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you committed the offense of injury to a child, elderly, or disabled individual November 14th of 2024. And is that true or not true? All right, did you enter your plea of not true to count 1 freely and voluntarily? All right, then I'm going to enter that plea of not true on that count. I'm going to reset the case for sentencing hearing. About how long do you anticipate?
I want to know more than that.
About an hour or so, so we could do it maybe at the end of a docket. So we'll set it for 11, probably on a Monday, just at the end of one of these dockets, unless I can find a time when we're not in trial on another week.
Okay.
And that'll give y'all time for any
You can
evidence.
just let me know, or have Kelly or somebody let me know, so we'll be witnesses here.
We'll do it. She'll be back tomorrow, and we'll get that set in the next couple of days. If I can get an updated pre-sentence report, that would be great as well. And then we'll see y'all back at sentencing. All
Sounds
right.
good, Judge.
Thank you. We need to get his print, please. Good morning. Are you Shay Brooks?
Morning, Shy.
Shy. And Mr. Brooks, in cause number 24, DCCR 2034, was previously in court, entered a plea of guilty to evading arrest or detention with the use of a vehicle, received the pre-sentence report. Has everyone had an opportunity to review the report?
State has, Judge.
Any additions or corrections?
Nothing.
Not from the state, Judge. We just asked the court following the reading of the part.
Thank you, sir. All right, Mr. Brooks, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and find you guilty of evading arrest or detention with the use of a vehicle. Sentence you to a term of 10 years in prison, but probate that for a term of 10 years. You order to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have the felony conviction. Well, no, it's not. I'm sorry. You do have, for all practical purposes, your case here in court is over if you do everything you're supposed to. And you'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be facing that 10-year sentence that you've already agreed to. Do you understand?
Yes.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. If you'll just have a seat here in the courtroom, probation will call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, sir. Thank you.
Thanks, Judge.
Thank you. Paul McCorvey, Mr. Lewis. Good morning. Are you Alexandria Bledsoe? And this is 25 DCCR 0004. Ms. Bledsoe was previously in court and entered a plea of guilty to the state jail felony offense of abandoning or endangering a child with intent to return. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor. Yes, sir.
Any additions or corrections?
Only one minor thing my client would bring up. The name of her employer was Cigna, correct, or Sigma? Sigma, it was listed as Sigma, and she was just worried that that might be an
Okay.
issue. I told her not to worry
Don't worry
about it,
about
but
that.
she wanted to bring it to the court's attention.
Okay, thank you very much. Anything else?
So, Your Honor.
All right, ma'am, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include completing an intensive parenting class. If you haven't already done that through CPS, there's going to be something through probation that you're going to need to do, obviously. If you do everything that you're supposed to on this probation and follow all of the rules and conditions, then this is an excellent opportunity because you do not have a felony conviction on your record. The other side to that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and you could go to the state jail prison for up to 2 years. Do you understand? Okay. Obviously, I would like to think that this was a huge wake-up call because this could have been very, very bad. And so take care of your child, take care of the classes, make sure you make all of the right decisions when it comes to that, and you shouldn't have any issue. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am. Thank you, Mr. Rennick. And Mr. Rennick, you also have Patrick Gallagher
Yes.
sentencing, 24 DCCR 2422
Yes, Your Honor.
sentencing. No, you're Tajuan Mack. Mr. Mack, we've had issues with you and your drug patch now. I can't even tell you how many times, countless number of times. You were here not that long ago. Hold on. You were here. I told you last time you were here that I didn't care what it took for you to have a testable patch on when you went back to have it tested. I got an email from Johnny's Auto dated last Thursday, the 25th, where it says you came in without a testable patch on, you claim it fell off, they put a new one on you, and they will update us. So you went in without a testable patch last week, is that right?
Oh, no, man. I'm not even with Johnny's no more. I get my patch from Al Reed.
They test you, Al Reed tested you?
Yeah.
So you didn't go to Johnny's?
Oh,
When did you go to Al Reed?
Call Al Reed and call Johnny's too. Why would they send us an email that says, do you have a patch on right now? When did you get it?
Thursday? Friday?
Okay, from where?
Al Reed.
From his office?
It's mine.
Or he might, because Al probably uses Johnny's. Did you have a patch on when you went to see Al Reed last week?
Answer this. Al.
Answer yes or no. Are you, tell me the truth, because we're going to get to the bottom of it right now. You had a testable patch on last week.
It's mine.
Well, you had a patch on. I don't know if it's testable or not. He's
I gave it to him to test, so yeah.
Did they take it off your arm,
Yes, ma'am.
or you handed it to him?
No, they said that, like, I feel it, and she get the little tweezers, and she take it right.
That happened last Thursday.
Yes, ma'am. I owe Johnny some money on my previous patch.
What?
I owe Johnny some money.
Okay, but that's not what they're saying, so I need to find out why they're saying specifically with regard to you that you went in without a patch on.
Did you check with probation?
Probation doesn't have anything to do
Well,
with
if you get drug testing in court,
I'm tired of doing that. It's what I've done every time we've been here. I'm not gonna keep doing that. We're gonna either have patches that work or he keeps on or not. I just gotta see why they sent this email. All right, we gotta get our jury seated. So here's what I'm gonna do. I'm gonna let Anna work on figuring this out with talking to Johnny's and Al Reed. I'm going to have you guys back here. Plan on being back this coming Monday. I'm gonna reset it to Monday. If it gets worked out and I don't need y'all here, we'll send you a new reset for a different day. But plan on being back in 1 week, and that way, if something happens, we'll figure it out. But we're gonna talk to Johnny's. We're gonna talk to Al Reed.
I could just wait, wait.
I gotta get a jury seated.
All right.
We're already at 2 o'clock, and I've had a jury waiting for an hour. So,
Johnny's, the bondsman said they've been putting it on him since August 25th. I
Okay.
talked to Johnny.
Call
What's the
Johnny's.
date on that?
That's all right. All right, y'all can go.
What's the date on
We'll send you a reset. It was last week. I said 9:25. All right, y'all can go.
All right, thank
Good morning.
How you doing, ma'am?
Good. Are you Brian Battle?
Yes, ma'am.
And Mr. Battle, this is your initial appearance. Let me get it pulled up. In cause number 25, DCCR 1050. Well, the computer knows it's Monday. You're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from July 10th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes, ma'am.
You have. Did you hire someone?
No, ma'am.
Okay. So what I do, Mr. Battle, since you just got out of jail and made that bond, is I'm going to reset your case for about 30 days to give you some time to try to hire a lawyer. If you get a lawyer hired before the next court date, then bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so that I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand?
Yes, ma'am.
All right, if you'll step in front of the clerk, she'll give you a reset notice.